you would normally give the tenant a 30-day notice of termination of tenancy. If the tenant has been in the property over a year, you would give the tenant a 60-day notice of termination of tenancy. So step one is the foundation. It is the first step towards the eviction process. As many of you have already heard that some cities and counties are preventing landlords from serving a 3-day notice to pay rent or quit during this pandemic. So that is the first roadblock that you as a property owner or property manager have encountered, because the cities or the counties are saying, wait a minute, we're in a pandemic. You cannot serve a 3-day notice to pay rent or quit. Some cities are preventing property owners from serving a 30 or 60-day notice of termination of tenancy. Others are not. So this is the first step, the initial notice. Once this initial notice is served and the tenant did not comply with the notice, meaning they did not pay the past due rent or vacate, then we move on to step number 2. Step 2 is filing the eviction complaint. When we file the eviction complaint, on the complaint, we inform the court, Your Honor, the plaintiff is the property owner of this property. The tenant was served with a 3-day notice, a 30-day notice, or a 60-day notice of termination of tenancy. The tenant has failed to comply with such notice. I, as a property owner, am asking for possession of the property in addition to past due rent and damages. When we file that eviction complaint, we get a document that's called a summons. The summons is a legal document that we serve on the tenants, informing the tenant, an eviction complaint has been filed against you. You have 5 business days to file an answer in court. The court does not have jurisdiction over the tenant until that summons is served on the tenant. So you cannot move the case along until the tenant has been served with the summons and the complaint, and you file with the court proof of such document. I want you to remember this. The summons is very important in step number 2, because that is the way that we serve the tenants with the eviction complaint. Because that's going to come into play later in this presentation. Once we serve the tenant with the eviction complaint and the summons, they have 5 business days to file their response in court. Once they file their response in court, which is called the answer, then we move on to step number 3, which is the trial. At the trial, we go in front of the judge. The property owner presents all their evidence. Your Honor, we have a tenant. They've been in possession of the property ever since, 2 years ago. They became delinquent on their rent payment. We served them with a 3-day notice. They failed to pay rent. Now we're asking for possession of the property. The tenant is also afforded an opportunity to be heard. At the end of the trial, if the plaintiff has presented all the required evidence, then the judge will sign a judgment in favor of the plaintiff, indicating that the plaintiff is entitled to possession of the property. After the trial, that does not mean that the tenant can take off. The property owner can take off and go to the actual property and evict the tenant. No, all this means is that the property owner was successful at trial and that they can proceed with a sheriff lockout. So once we have that judgment, we move on to step number 4. We ask the court clerk to issue what's called a writ of possession. The writ of possession instructs the sheriff's department to evict the tenant. The writ of possession tells the sheriffs there was a trial, the property owner won, you need to evict the tenants. Once we get this writ of possession, it normally takes us about a week to receive it back from the court after the trial. Then we send it over to the sheriff's department. The sheriff's department will look at their calendar and then schedule the lockout date. Pre-pandemic, the lockout was normally anywhere from 3 to 5 weeks out from whenever we submitted the request. Now, post-pandemic, you're looking at about at least 2 months for all those evictions that went to trial prior to the pandemic or are going to trial now. Pre-COVID-19, in order for me to evict a tenant based on a non-payment of rent using a 3-day notice to pay rent or quit, it would take me about a month and a half to go through this entire process. That was best case scenario. So a month and a half to serve the notice, file the complaint, go to trial, get the writ of possession, get the sheriff lockout, a month and a half. That was best case scenario, because if the tenant did file for bankruptcy or filed any frivolous motions or evaded service, then obviously it delayed the process. If I was evicting someone for, you just wanted to evict them and I was using a 60-day notice of termination of tenancy, then the turnaround time would be about 4 months. 2 months of this initial notice and then another 2 months to move through this process. So keep that in mind. That was best case scenario pre-COVID. So what was the first roadblock that my office encountered when COVID-19 came to the United States? Well, the courts were closed. Now the courts are open, but from March up until late May, mid-June, the courts were closed. So imagine, for about 10 weeks, the courts were closed. So if we go back to our eviction chart here, if the courts were closed, I had a lot of clients that had to serve these initial notices, and then the next step was to file the eviction complaint, and we just couldn't because the courts were closed. So that was the first roadblock that we encountered. Obviously, now the courts are opened, but that does not mean that you're in the green to proceed with an eviction. And what do I mean by that? The Judicial Council is the policy-making body of the California courts. California is the largest court system in the nation. On April 6th, it met and it approved 11 emergency rules. The order is 30 pages long. Rule number 1 has to deal with evictions. So what is that rule? Rule number 1, an eviction summons on an unlawful detainer complaint cannot be issued until one of the following occurs: 90 days after the state of emergency related to COVID-19 is lifted, or this order is appealed or amended by the Judicial Council. There is a small exception if it's necessary to protect the public health and safety. But pay close attention. It says an eviction summons on an unlawful detainer complaint cannot be issued until one of the following occurs: 90 days after the state of emergency related COVID-19 is lifted. God only knows when this will happen. As it stands right now, we're still in a state of emergency. So if we go back to our chart, even though the courts are opened and we can, ideally move on to step number 2, you cannot move any eviction cases along, because what's going to happen if you file an eviction complaint? Yes, the court clerk may put a case number on your complaint, but they're not going to issue the summons. The summons is the most important document in a lawsuit, because with that summons, we serve the tenant. The Judicial Council actually met earlier in this month to try to amend this rule. They wanted to say that in, I believe, August, it would be okay to issue the summons, but they did not end up voting on the matter. I do not know if they're going to vote anytime soon. I've been looking to see if there's anything online, but at this moment, there's absolutely nothing online that indicates when the voting will take place. It may never take place. So obviously this order can be amended by the Judicial Council, and that was the purpose of their meeting earlier this month, but it was useless because they didn't end up voting. So we would just, as of right now, we would have to wait until the state of emergency is lifted. Then 3 months after that date, we would be able to get an eviction summons issued. The exception here, if it's necessary to protect the public health and safety, that would be if a tenant is operating the property in such a manner that it would be likely that the neighboring houses would also, be damaged in a fire or something like that. So it's not an easy showing. I understand that a lot of you that have rental properties or managed properties are in a very bad position because you rely on their rent payment to make your mortgage. That's not a good enough reason to meet this exception. Unfortunately, it's not. The other rule pertaining to evictions is that in cases where the tenant had already filed an answer and the next step was to request a trial date, the trials are going to be set 60 days after the request was made. So if we go back to our chart, when I would request a trial date, it would normally get scheduled within 2 weeks. So let's say that prior to the court closing, the tenant had filed an answer and then the court's closed. So now that they're open, you can request your trial date, but your trial date isn't going to be until, let's say, late August, maybe September. So you can see how that affects this timeline here, because if you're not going to trial until September, you're not going to get the sheriff lockout until December or possibly 2021. Before the Judicial Council met, the governor, obviously Governor Newsom, Mayor Garcetti, were implementing several orders to kind of protect the tenants because the Judicial Council hadn't met. Obviously, the rule implemented by the Judicial Council supersedes all these other orders made by these local counties. So remember, whenever Governor Newsom makes an order, it applies to the entire state of California. When Mayor Garcetti makes an order, it only applies to the city of LA. It does not apply to the entire county of LA. I know people get confused because when he speaks, he sort of speaks on behalf of LA County, but not really. It's just the city of LA that he's speaking in regards to. So Governor Newsom made this order. It was extended until July 28th. He basically indicated that a tenant, once they're served with a summons, they have 60 days to respond. Obviously, that doesn't even come into play now because the summons can't be issued. So a tenant doesn't have anything to respond to if a summons isn't issued. So just remember, this was implemented prior to the Judicial Council order. Governor Newsom basically stated if a tenant informed his landlord in writing that he's unable to pay rent due to reasons related to COVID-19, they have 60 days to respond to the eviction complaint. But this is kind of a moot issue because no summons can be issued right now. The city of LA implemented this order. This was signed on March 31st, 2020. Mayor Garcetti declared the city of LA to be in a local emergency period that began on March 4th, and it ends, we have no idea. So in the city of LA, if it's a residential property, absolutely no evictions can take place. You cannot serve a 3-day notice, and you cannot serve a 30 or a 60-day notice of termination of tenancy on a residential property. This is huge because if you're listing a residential property in LA, unless the tenants voluntarily vacate, you will not be able to evict them because Mayor Garcetti is saying, in my city, you cannot serve a 3-day notice, a 30-day notice, or a 60-day notice of termination of tenancy until this local emergency period has ended. If it's pertaining to a commercial property, you cannot serve a 3-day notice to pay rent or quit. Technically, for a commercial tenant, you would be able to serve a 30-day notice of termination of tenancy, but what good does that do you? Absolutely nothing, because if the tenant doesn't leave, you cannot file an eviction complaint. Mayor Garcetti has indicated that in the city of LA, residential tenants have 1 year to repay the past due rent from the expiration of the local emergency period. So whatever date goes right here, the tenants will have 1 year from that date. For commercial tenants, they have 3 months from this date. No late fees can be assessed for residential tenants. The landlord needs to provide a notice of this ordinance to the tenants. It does not eliminate the obligation to pay rent. So again, this only applies to the city of LA, not the county of LA. Long Beach also implemented certain laws that will protect tenants. So in the city of Long Beach, if a tenant is unable to pay rent between March 4th and July 31st, this was recently extended due to a reduction in income caused by COVID-19. They must notify their landlords in writing and provide documentation, and they will have until November 30th to pay the past due rent. No late charges can be assessed during this time. I think the November 30th date will get extended. I always get asked, well, Georgina, what if the tenants don't provide any documentation? Guess what? You're out of luck, because if we go back to this chart, okay, you can't serve a 3-day notice for the non-payment of rent. And you're like, well, what if the tenant never provided documentation? You're still out of luck, because even if you serve a notice on the tenant, you can't get the summons issued in step 2. So you're stuck in step 1 for a very long time, and I don't know how long that time will be. San Bernardino County also adopted several resolutions suspending evictions and foreclosures. I think for San Bernardino County, they mostly deal with the non-payment of rent. So the summary. The courts were closed, so we couldn't file any eviction cases or move them along. But now the courts are reopened. So what does that mean? Still, we can't do anything. No summons may be issued until 90 days after the state of emergency is lifted, or when the Judicial Council decides to vote on that matter. And for tenants that have filed their answer in court, the trials will be set 60 days from the request. Recommendations: work something out with the tenants. Some money is better than nothing. If you are relying on that rent to pay your mortgage, call your loan servicer to go over options. Even after the state of emergency is lifted, try to work something with your tenants. I think the courts are going to be swamped with cases, and it's going to be a very long process. Also, things are changing. So for those of you that have commercial tenants, you may not want to lose that commercial tenant, because if everyone's going to be working from home, who's going to rent your commercial location? You need to look at the local rules. So in the Q&A, do not ask me regarding specific cities, because each city is different. It all depends where your property is located. So if the city where your property is located has not implemented any rules pertaining to evictions, then you need to look at the county level and go from there. Where would you find if your city has implemented an eviction law? You know, you just Google Upland, the city of Upland, eviction halt, or something like that. So I'm not familiar with every single city. I've listed some cities here just for discussion purposes. But let's go back to the chart so we can discuss this. I'm going to get so many questions from listing agents and buyer's agents that will want to know, well, what should I do when a property is tenant occupied? If you are the listing agent and your client's goal is to sell the property, you need to sell that property tenant occupied. You need to make sure that the RPA reflects that the property is going to be sold tenant occupied. Why? There is no way that your client, the seller, will be able to evict the tenants right now, even if they were to serve a 30 or 60-day notice of termination of tenancy. If the tenant voluntarily vacates, that's a different story. But if you have to serve the tenant a 30 or 60-day notice of termination of tenancy and they do not vacate, there's nothing you can do because, like I mentioned, the courts are not issuing the eviction summons. So there's no way that you're going to be able to proceed with the eviction. So you listing agents, you don't want to have your client be in breach of contract because the buyer says, hey, we're supposed to close and the property needs to be vacant, and it's not vacant. For a buyer's agent, I would not close escrow if the property is tenant occupied. Can you just imagine the mess that you would get your client into if this client is buying the property to move into and then pay the mortgage, but instead it's tenant occupied, they can't move in, the tenant's not paying rent, so that means they have to come out of pocket in order to meet the mortgage payment. So do not close escrow on a property that's tenant occupied when your client intends to move in. With that being said, even if your client is an investor and he's relying on that rent income to pay the mortgage, they need to be informed that the evictions can't be moved along at this moment. So an investor may think, well, I'll just buy the property and then evict the tenants. Well, good luck. There's nothing we can do at this moment. A summons cannot be issued. So be very careful not to get your clients in a predicament that you have no idea when it's going to be resolved, because no one knows when COVID-19 is going away. So that's that on COVID-19 and the eviction process. Now I want to discuss the rent cap and just cause eviction law. This law took effect on January 1st, 2020, but a lot of people have forgotten about this law because we're so bogged down with COVID and staying at home and wearing masks and not being able to do fun things. So there's this new law that the state of California adopted. This new law places restrictions on evictions and rent increases. There are exceptions to this law. One of the exemptions is that single family residents are exempt from this new law. So if you rent out a single family residence, you do not need to comply with this law. However, you do need to provide notice to your tenants that this law exists and that the property is exempt. And there's actually a deadline. Notice needs to be provided by August 1st. So you have about a month left to be able to provide this notice to your tenant and inform them, yes, tenant, California adopted this new rent control law, but it doesn't apply to you. For those of you that have a single family residence with an additional dwelling unit, that property is exempt so long as you as the owner reside in the primary residence. So anything a duplex and up, this new law applies to it. So remember, if your property is excluded because it's a single family residence or it's a single family residence with an additional dwelling unit and you reside in the primary residence, then your property is excluded, but you need to provide notice of this law by August 1st to your tenant, or any leases that are signed on July 1st and on need to include the notice. In your zip forms, when you go in to create a lease, it will automatically add the rent cap and just cause addendum. So it is CAR form RCJC. So if you look at rent cap and just cause addendum in your zip forms, it is a 3-page document. It provides the breakdown of the properties that are exempt and those that are not. So it would behoove you to take some time to look at that document and serve it on your tenant. Okay, so good thing you guys aren't here in person because I'm coughing and I can't stop coughing. So what is the summary of the law? The gist of it is, If your property is a duplex or anything bigger, you cannot evict the tenants unless there's a breach of the lease. Meaning, if it's a duplex, you can no longer serve your tenants a 30 or a 60-day notice of termination of tenancy just because you want them out. No, you cannot do that. You will only be able to do that if you're selling the property or you're having a family member move into a property. So for those of you that are representing a buyer and they're buying a duplex or anything bigger and it's tenant occupied, you need to inform them that they're not going to be able to evict the tenants. They're stuck with those tenants. They're married to them. So just be very careful. So obviously, if a tenant falls behind on their rent payment, you will be able to evict them using a 3-day notice to pay rent or quit. But just because you don't like the tenants, that's not going to be a good enough reason to evict your tenants. If you are going to be selling the property or moving into the property and you're evicting your tenants, you will need to pay moving expenses. Again, this only applies to properties that are not exempt if it's a duplex or bigger. If it's a single family residence and it's exempt and you're evicting the tenants, you do not need to pay moving expenses. You do need to provide notice of the law. So how do you provide notice? You can use the CAR form that is found in your zip forms. It's a 3-page document. If the property is exempt, there is a box on the bottom of the 2nd page. You're going to mark that box indicating that the property is exempt. Then you're going to serve it on your tenants. How do you serve it? Well, if your tenants are in agreement to sign this document and for it to be part of your rental agreement, then you can just email it to your clients. They can sign it, and then now it's part of your rental agreement. If your tenants don't really cooperate with you and they're not willing to sign this document, you will need to serve this document attached to a notice of change in terms of tenancy. And how would you serve that notice? You would have to serve it by personal delivery. So you go to the property, you knock on the door, and you physically hand a copy to your tenant, and you make note of when you serve that document. Or you go to the property, you knock on the door and no one's there. In that case, you knock on the door and so obviously no one opened the door. So you'll just post a copy on the door, snap a picture, and mail a copy regular mail. Don't get fancy on me with certified or return receipt requested, just regular mail, and you will make a note of when you mailed it. So just to reiterate, how do you serve this notice? If the tenant is in agreement and they're willing to sign the notice, you can just send it to them via email, DocuSign, whatever the case may be. They sign it, you keep it in your file. If the tenant is not agreeable to signing this document, then you would have to go to the property to serve them personally. You knock on the door, they open the door, and you say, hey, tenant, here's a notice of change in terms of tenancy. Here you go. You make note of the day and time that you personally handed the document to the tenant. If you go there and no one opens the door, then you post a copy on the door and you mail a copy regular mail. Like I said, do not get fancy. Regular mail suffices. So the gist of this law is, this law does not apply to single family residence or a single family residence that has an additional dwelling unit. However, for you to be exempt, you do need to provide notice of this new law. If the property is a duplex or anything bigger, then there are restrictions on the eviction of tenants and rent increase. So you can only increase the rent 5% every year, plus the cost of inflation in that particular city. So again, if you're representing a buyer and you know that the rents are super low, you need to advise your buyer to sit down with an attorney and discuss what options they have, because maybe it would not be a good business decision to purchase the property, because you won't be able to increase the rent to get it up to market value. You're only going to be able to do the 5% every single year. I think that is all that I wanted to cover today. So I am going to open it up for questions. I know it's a lot. The biggest takeaway from today's presentation is right now, during this pandemic, an eviction summons cannot be issued. So remember, even if this particular city allows you to serve a 30 or 60-day notice, it will get you nowhere if the tenant does not voluntarily vacate, because it's very likely that by the time the 60 days are up, still an eviction summons wouldn't be able to be issued. So be very cautious when you're presenting your sellers and your buyers. As far as the rent cap and just cause eviction law, keep in mind that notices need to be served by August 1st. So every single tenant needs to receive a copy of this notice. If the property is exempt, then the notice will indicate on the bottom of the second page that that particular property is exempt from the new law. If the property is not exempt, meaning it's a duplex or anything bigger, then you would still serve the notice, but you wouldn't mark that box on the second page indicating that the property is exempt. So I'm going to go back to this slide and I'm going to look at your questions now. So remember, type your questions in the Q&A or the chat. So in the Q&A, I have CC is also example as townhouse and condo. Yes, a townhouse and a condo is exempt. So if you do rent out a townhouse or condo, your property is exempt. Just make sure to serve the rent cap notice on the tenant indicating that the property is exempt. So remember, there's a box on the bottom of the second page. Stephen, does LA County have restrictions on 30 or 60-day notice of termination of tenancy? Like I mentioned, the city of LA does. As far as the other cities within the county of LA, I do not know. You would have to look at the city that you're dealing with. You know, there are a ton of cities. I couldn't look them all up. Lawrence, does AB 148T notification requirement apply to multifamily residents not in rent control? Yes. So this notice applies to every single property in the state of California that is not already subject to rent control. So if your property is in the city of LA and it's already subject to rent control, you don't have to worry about this because they fall under the jurisdiction of rent control. However, if that property is not under rent control, then this does apply to it. And I forgot there's another exemption. If it's a fairly new property, if the certificate of occupancy was issued within the previous 15 years, the property is exempt. So look at the form that I mentioned, the CAR form, it'll list all the exemptions. Deborah, what notice are you referring to that we should just do regular mail? I'm referring to CAR form RCJC, the rent cap, and just cause addendum form. Matt, does the new AB 1482 apply to month-to-month tenancies carrying over from a lease started before January 1st? Yes, this new law applies to every single property if the tenant has been in the property over a year. So if the tenancy is month to month because the initial term already expired and the initial term was for a year, then yes, this applies. So this law applies to every single tenant that's been in the property over a year. I think that's it. Did I answer everyone's questions? Does anyone have any other questions? Okay, I'm waiting. Lawrence is going to type a question. Okay, so the question, Joey, how much your company normally charge for helping agents evict tenants? My retainer is $1,500. 500 goes towards court costs, and the remaining 1,000 gets used towards legal fees. Lawrence, for new leases signed, we can freely include language about rent cap and this bills as one of the clauses. Yes, if you're signing a new lease, the zip forms automatically incorporates this new car addendum. Do we need to print that out during the leasing appointment? No, you just, once you present the tenant with the lease, it would have the addendum. Judy, about the 3-day notice, can it be served earlier before the 30 or 60-day notice? No, most cities are preventing from 3-day notices to be served on tenants. You're welcome, Lawrence. Imelda wants my contact information. So if your clients requiring more information, they can schedule consultation. The consultation is $80 for up to an hour. They can schedule the appointment on my website, which shows my availability, or they can call the office, but payment is required at the time of booking. Can you, Tiffany, can you repeat how many days of processing time for each step? Unfortunately, Tiffany, right now, I wouldn't know. But pre-COVID-19, if we were evicting someone based on a non-payment of rent, it would take about a month and a half. If we're evicting someone based on a 60-day notice, it would take about 4 months. Now, with the courts being closed for such a long time, not knowing when the summons are going to be issued, I can't really give you an estimate. Matt, no, the AB 1482 does not apply to commercial properties. Santiago, you're gonna need to speak with your board if you want a copy of the presentation. Any other questions?
Just so that everybody knows, this was recorded and it'll be on the Tri-County's website.
All right, so I think that's it, right? Unless anyone has any other questions.
Thank you.
All right, well, have a nice day and take care, everyone.
Okay, bye.
Bye.